would be likely to affect their principal's willingness to enter into or complete the transaction? Might their obligation to pay the deficiency balance affect their willingness to enter into the transaction? Might tax consequences affect their willingness to enter into the transaction? Do you have a duty to disclose that there may be deficiency liability or tax liability? Are you going to go so far as to tell them what that is? Nope. Nope. Now somebody this morning asked me a question about flipping of a property. Flipping of a property. Some of these properties are being flipped by, to investors. Do you guys have a duty to disclose that?
Yes.
Yep. Yep. Might how much the property sell for ultimately affect how much the borrower is obligated to pay on the loans plural, encumbering the property. Yeah. Yeah. Go next. Yeah, see that there, the bottom one? That's talking about the flip. Yes, county. Good exercise reasonable care. Here's one. How many of you guys have seen Law and Order, Matlock, LA Law? You guys see those lawyer shows? People love lawyer shows for some reason. I don't know why. I can't stand to watch it. They create a misperception that we're in our society that we're innocent until proven guilty. Well, that's generally true. But what about if you're a fiduciary? Ooh. They don't talk about that on Law and Order. I don't even remember them even using the term fiduciary. If you're a fiduciary, the burden, all that has to be shown is that the fiduciary relationship exists. Once it's shown that the fiduciary relationship exists, then the fiduciary is in a position where they've got to show that they fulfill their fiduciary duty of care. And you may say, well, that doesn't seem right. Shouldn't the guy suing me have to show that? Nope. Nope. That's not fair. What do our parents say about life being fair? Right? If you're my generation, Mom and Dad, you said, life isn't fair. Get over it. Right? So be careful. What to disclose about a short sale? Here again, I keep forgetting to bring my car forms. I want to bring my car forms so I can read you what the disclosures in the car forms. Now in the car forms, they have a couple sentences of a disclosure that basically say, we're not providing you with legal advice, we're not providing you with tax advice, go talk to a legal professional, go talk to a tax professional. Yes, well there's two. But here, I like my disclosure a little better. My disclosure, which I would use separate and apart from the car forms. Yes, I would use the car form, but in addition to that, I would use a disclosure something like this. Please be advised that by going through with this short sale, you could be held financially liable for the unpaid balance on one or more of the loans collateralized by your property. If you lied on your credit application, then your obligation to pay any unpaid balance could prove to be non-dischargeable in bankruptcy. Also, there is a chance that you could incur tax debt by going forward with this sale. We are not lawyers, and we are not tax professionals. To this end, you are being strongly urged to seek the advice of both legal counsel and a tax professional in reaching your decision to sell your property. If you choose not to obtain the assistance of legal counsel or the assistance of a tax professional, then you are relying on your own independent judgment in reaching your decision to sell the property. By signing below, you specifically represent and warrant that you have read this disclosure, that you understand this disclosure, and that you are not relying on any representations or warranties of your real estate agent and or broker, either express or implied, in reaching your decision to sell. I like that one.
You would not get any client, but
I got quite a authorship on that, huh? Yeah, I like that one. And I like it to require the client's signature and have them date it. And I also like the idea of them signing it in a setting where this is the only document that they're signing at that particular time. So it's not, they can't come back and say, I didn't know, it was buried in with a bunch of other paperwork. And you never, never want to say to an opposing attorney that the reason you didn't give this disclosure is because you were afraid he wouldn't sign it and wouldn't do the deal. Do you think that happens?
oh yes.
Yeah. Yeah. I'm a fan, ladies and gentlemen, of using this disclosure more than once with the same client. It makes it incredibly challenging for them to come back and say, I didn't know. I didn't know. I didn't know. What happens if you say, I know I'm supposed to make the disclosure, but if I do that, gosh, a number of these people aren't going to do a short sale with me. Then what happens? Well, if the outcome would have been different, but for your involvement, you might have yourself a problem. What if the client has one loan or two loans on his property, both with the same lender? Sorry?
I do.
He's here.
I couldn't hear that.
He's here to do this.
What's that?
I guess I do it.
No. We're talking about what happens if we don't have them sign a disclosure.
Surprise!
Surprise! Yeah. Then you run the risk of a lawyer contacting you, asking you to write a check. Now, ladies and gentlemen, I'm starting to get more and more real estate professionals coming in that are on the receiving end of lawsuits. What you have to understand, and I do not want anybody in this room to be on the receiving end of a lawsuit. The minute you are served with a lawsuit, you have been placed into a position where no matter what you do, you are spending money. And large sums of money. If you go to a lawyer and hire a lawyer to defend yourself, you're spending large sums of money. If you do nothing, you will spend large sums of money. It will be against your will. It will be involuntary. But you will be separated from your money. That's the position you are placed in. Now, hopefully you have insurance. And there's going to be insurance that will step in and take over the defense. But if not, you have every bit been placed into a position where no matter what you do, you're going to be separated from your money. Bankruptcy may be in your horizon, in your near future. Okay? So those disclosures kind of take on a whole new level of importance, right? Okay. Save yourself a lot of grief. When a client comes in on a short sale, do take a look at his loan application. Do have a conversation with them about their assets. It goes to whether or not it makes sense to make financial disclosure. Now, I caution here as well, as you may want to tell them that they may want to make this disclosure to a lawyer because their communication with the lawyer is protected under what's called the attorney-client privilege. So nobody can force the lawyer to divulge the confidences reposed within the lawyer by the client. That kind of privilege does not work with you. So if the creditor becomes aware that the client is working with you, though it's unlikely to happen, it's possible that you can get hit with what's called a business record subpoena, or a subpoena, ducis tecum, which is a post-judgment subpoena,